ऑनरेबल जस्टिस वी गोपाला गौड़ा साहब का लीगल ओपिनियन और हम जो पोजीशन पेपर दिए थे 2018 में 21st लॉ कमीशन को, वो सब ये बता रहा है कि यूसीसी की इस देश को जरूरत नहीं है। अगर आपको मेरी बात का यकीन नहीं है तो जस्टिस BS चौहान जो 21st लॉ कमीशन में क्या बोले थे वो भी सुन लो आप, वरना आप लोग ब्रेकिंग न्यूज बोल के ओवैसी को सूली पे चढ़ा देंगे। Cultural diversity cannot be compromised to the extent that our urge for uniformity in itself becomes a reason for threat to the territorial integrity of the nation. इतना बड़ा स्टेटमेंट जस्टिस BS चौहान दिए थे। अब जस्टिस वी गोपाला गौड़ा साहब को हम 4 क्वेश्चन पूछे। नंबर 1 क्वेरी था, आप मैं टाइम बचाने के लिए मैं आपको उसका आप खुद पढ़ लो वो 4 क्वेरीज क्या थे। एक था व्हाट इज द स्कोप ऑफ आर्टिकल 44 ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया एंड वेदर द पार्लियामेंट इन एक्सरसाइज लेजिस्लेटिव पावर अंडर रेलेवेंट एंट्री नंबर 5 ऑफ कंकरेंट लिस्ट ऑफ शेड्यूल 7 शेड्यूल ऑफ कॉन्स्टिट्यूशन कैन ब्रिंग रिफॉर्म्स ऑफ पर्सनल लॉज बी जस्टिफाइड दो द स्टेट आर्टिकल एज स्पेसिफिक लिमिट एम्बिट। तो ऐसे ही हम लोग सेकेंड क्वेश्चन क्वेरी पूछे थे, वेदर कोडिफाइंग सर्टन एस्पेक्ट्स ऑफ पर्सनल लॉज of certain communities on the basis of proposed law commission consultation paper and concern article 44 and the same are violation of fundamental rights guaranteed under article 25 and 29. Third हमारा query था whether codifying personal laws under the guise of article 44 would not impact the pluralism within these minority groups, religious groups such as Sikhs, Buddhists and Jains who are governed by provision in Hindu law. Fourth, whether uniform civil code as contemplated under article 44 of the Constitution of India would not adversely impact the legal status of Hindu undivided family as provided in Hindu law. Fifth था whether the statutory enactment of uniform civil code by Uttarakhand state in exercise of legislative power would not be contrary to article 44 of the Constitution of India as it has jurisdiction throughout the territory of India. तो ये पहले लास्ट क्वेश्चन जो है ना, आप उसको पहले ले लेते हैं, जो उत्तराखंड का आजकल बहुत वो चल रहा है। Honorable Justice V. Gopala Gowda retired साहब क्या बोल रहे? Can a state make a law? State government make a law on UCC. Uniform Civil Code essential refers to a common set of laws governing personal matters such as marriage, divorce, adoption, inheritance and succession as per Schedule 7 of the Constitution. Such subjects come in concurrent list entry number 5 wherein powers to legislate vest with both Parliament and state legislatures. Accordingly, the state legislature may introduce amendments to the personal laws enacted by Parliament, but it cannot be stretched to include that enactment of UCC for a particular state. तो उत्तराखंड का UCC नहीं बोल सकते उसको. If Uttarakhand or any state government brings any such legislation, it will require presidential assent under Article 254 of the Constitution of India. UCC in Article 44 of the Constitution mandates UCC throughout the territory of India, which was confirmed by the then Law Minister in February 2022. This constitutional position is further confirmed by the manifestos released by political parties. For instance, UCC was a part of a manifesto of 2009 general elections, but was not specifically highlighted in the manifesto of the party of Uttarakhand Assembly elections. Therefore, I am of the view that Uttarakhand state government enacting the statutory enactment Uniform Civil Code is not sustainable in law. ये अब आपको जो 4 क्वेरीज जो हम पूछे थे उसमें से इम्पॉर्टेंट मैं आपको बता देना चाह रहा हूं, जिसमें गोपाला गौड़ा साहब वही बात बोले जो हम अपने नोट में दिए कि बाबा साहब अम्बेडकर क्या बोले थे आर्टिकल जब ये आर्टिकल 44 आर्टिकल 35 था, डिबेट हो रही थी। फिर उन्होंने ये भी उसमें लिखे अपने ओपिनियन में, श्री BN Rao, the constitutional advisor to the Constituent Assembly stated, directive principles are intended as moral precepts for the authorities of the state. They have at least an educative value. The great jurist Sir Ivor Jennings thought they were only pious aspirations. फिर Justice V. Gopala Gowda said the idea to adopt one code for all personal laws was considered antagonistic to Article 19, that is at present Article 25. Secondly, उन्होंने ये भी बोले, several Article 15(1), 16, 25, 26 and 29 are embedded in the Constitution with clear intention to protect religious freedom and customary rights. Likewise, Article 26b of Constitution ensures the freedom to manage the affairs of religion. Article 29 defines the right to conserve a distinctive culture. और इम्पॉर्टेंट पॉइंट जो ऑनरेबल जस्टिस वी गोपाला गौड़ा साहब हमारे लीगल ओपिनियन में ये भी दिए, जजमेंट्स का हवाला देके वो ये बोले, perusing this judgment it is obvious that the court has absolutely no idea. ये एक जज लिख रहा है, perusing these judgments it is obvious that the court has absolutely no idea what a UCC looks like and what such a court should do. In each case, it has been offered as a panacea for a particular issue with which the court was faced, as though the only problem with India's personal law is not their misogyny or obsolescence, but the lack of uniformity. The court in all these cases cling to Constitutional Directive Article 44 as it were a clear articulation of the idea what UCC is. फिर जस्टिस गोपाला गौड़ा साहब 371A 371G का हवाला दिए नागालैंड मिजोरम का, और फिर अपने ओपिनियन में जस्टिस ऑनरेबल गोपाल गौड़ा साहब ये भी दिए लिखे हैं, इवन द हिंदू कोड, मैं इसको छोड़ रहा हूँ, बहुत चीज़ें आप पढ़ सकते बाद में, इवन द हिंदू कोड विच सॉट टू क्रिएट यूनिफॉर्म लॉ गवर्निंग ऑल हिंदूज इज नॉट यूनिफॉर्म. Even the Hindu code which sought to create a uniform law governing all Hindus is not uniform in some of the most fundamental aspects of family law. The validity of marriage is linked to the customs and ceremonies of the particular community. The inheritance rights of the members of family is different for communities in Kerala and Tamil Nadu. Who is capable of being adopted also depends on the custom and usage. The Hindu Minority and Guardianship Act 1956 does not automatically apply to members of scheduled tribes. The claim that since Hindus, अब जो claim करते ये UCC होना बोल के, the claim that since Hindus are governed by uniform law, why not everyone else falls flat? Why not everyone else जो बोलते, it falls flat at the very first step. The law is not uniform for all Hindus in the first place. While no doubt the Hindu code makes several aspects of Hindu personal law uniform, it leaves custom and local practice undisturbed in several aspects. अब बीजेपी के UCC के बोलते है ना, गोवा में है. Even the much touted example UCC, the Portuguese Civil Procedure Act 1939, applicable to all communities in Goa, इसमें भी exception है. क्या exception है? It has different rules for Catholics, different rules for other communities, and it even recognizes bigamy for Hindus. अगर कोई हिंदू लेडी को 25 और 30 साल के दौरान बेटा नहीं हुआ तो उनके हस्बैंड सेकंड शादी कर सकते गोवा में, ये उसमें है. If UCC, Justice V. Gowda साहब लिख रहे, if UCC is really about uniformity, it will remove the requirement of religious ceremonies for the validity of marriages, abolish the concept of co-parcenary property, and remove all distinctions between converts and non-converts over the inheritance property. देखो आप remove distinction between converts. हिंदू मैरिज लॉ में डिवोर्स का ग्राउंड है कि अगर के हस्बैंड एंड वाइफ कन्वर्ट हो गए, वो डिवोर्स का ग्राउंड है, डिवोर्स का ग्राउंड है वो भी. If uniformity in all respects is not desirable, then that is an acknowledgement of the folly of promoting UCC with understanding the specifics of what it entails. If the goal is to address inequities in personal law of different religions, such inequities must be addressed on their own terms instead of demanding adherence to UCC. Whether it is the courts, the Constituent Assembly, or even those who are proposing the UCC as a panacea to gender inequality in laws or national integrity, no one seems to have a clear conception of what a court would actually look like. तो ये